Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We're talking about permissions to reapply and certain corresponding regulations that make it easier or harder. So let's look at a couple now. There's a section of the Immigration Nationality Act that deals specifically with aliens ordered removed. Okay, so notwithstanding the fact that the Board of Immigration Appeals and USCIS have challenged the validity of the regulation, it can still be argued that Form I-212 permission to reapply is available in the context of adjustment of status. So again, it's not a slam dunk, easy type of case to make, but it is possible. Now, the challenges to their validity have basically been brought up in various different contexts and various different regulations, but there is no clear-cut denial of eligibility to apply for it as the law stands now. So if you're applying for adjustment and you do have a deportation order, then you can try to apply for the permission to reapply rather than, for example, doing a motion to reopen. You might have a better chance of that without having to leave the country. Now, what about illegal reentry after 1 year of unlawful presence? We discussed this a little bit in prior videos, but normally you're barred for forever without even being able to apply for a waiver for 10 years, but you are in the country. So the Board of Immigration Appeal has addressed this issue, and basically the issue specifically is whether the adjustment of status is available under 245I for persons who have entered illegally after a deportation order and after 1 year of unlawful presence. So while the BIA did not specifically address simultaneous applications for permission to reapply and adjustment, it basically stated, unfortunately in that case, that the alien could not be granted permission to reapply either prospectively or retroactively because in his case the last departure from the United States occurred less than 10 years ago. However, in this particular case, while the BIA did not help the situation, there are ways that you might be able to argue in this particular limited situation that you are eligible, for this particular relief. Now, while this doesn't apply to everybody, in that case, the BIA, the Board of Immigration Appeals, found that the section of law basically giving a permanent inadmissibility is waived for certain Cubans, Central Americans, Haitian foreign nationals, and so forth. A very limited view in actuality, but the fact is that if those people were given it, and because the BIA didn't specifically say no to other elements, you should be eligible or may be eligible to have a good brief and good application for permission to reapply if you happen to fall under these particular elements. Okay? Alright, so more on the coming videos.